So now, after the commercial agreements section, now we move to another area of the law, which is corporate law and migration law. In these days, businessmen have got plenty of troubles, especially those who work cross-border, because they cannot either enter Russia very easily, or they have problems in, let's say, coming to Russia, and the workers cannot come. So all the let's say the business life, but also let's say the corporate life of a company is under pressure because people cannot travel very easily. So I will leave the floor to Igor Brazhevsky, who will explain us what can be done in terms of what in corporate formalities, taking into account the COVID, and what are the solutions to enter into Russia for those who need to come here for business reasons. Please, Igor, go ahead.
Yes, good morning to everyone who joined our webinar today. And following the introduction from Armando, I would like to say that COVID presented a lot of difficulties in terms of corporate and migration law aspects, and certain troubles arise. And in this presentation, we'll try to focus on the main problematic issues and possible solutions for this. So just I will open my presentation and we'll start. Okay, so first of all, when the situation with COVID arose in March this 2020, probably the first important topic in terms of corporate matters was approval of annual financial statements, because according to Russian legislation, the approval by the participants or shareholders of Russian legal entity shall be done according to certain deadlines. For limited liability companies, which is in Russia OOO, the deadline is 30th of April, and for joint stock company in Russian AO is 30th of June. Considering the difficulties of 2020, it was taken a decision to extend the deadlines, and the deadlines were prolonged till 30th of September for both limited liability companies and joint stock companies. We don't know how the situation will be in 2021 this year, but since the situation with COVID, unfortunately, is still a problem and can affect significantly the corporate life of the company in Russia, we could expect that probably the deadlines for 2021 shall be the same as 30th of September, but anyway, we will expect the changes in legislation and some information about it. Another important issue was the possibility of absentee voting, so the voting with the use of the ballots for annual meeting of participants or shareholders. Because according to the current legal regulation, the annual meeting of participants or shareholders are only possible by way of a joint meeting. So it means that all the participants or shareholders of the companies shall be physically present, at least according to the documents, or according to the real situation, it may differ. But in any case, in the document, we state that all the participants were present and were openly discussing all the issues of the agenda. And in some cases, it was possible to perform absentee voting, but not for annual meeting of participants or shareholders. However, as an exception for 2020, it was possible to conduct the annual meeting of participants or shareholders by way of absentee voting. So without physical presence, without joint meeting. At the same time, important to mention that specific provisions in the charter or specific internal document regulations shall be in the company in order to regulate the absentee voting meetings. This is especially important for limited liability companies because of the absence of direct regulation. For joint stock companies, it's not so critical because the regulations from the central bank quite in details determine all the procedures for joint stock companies. Another important issue was that meeting of participants and shareholders somehow should be possible by way of online meetings. This topic was discussed some time ago, but it was not so actual. But considering the situation with COVID, the online meetings became quite important and still quite important. However, the legal Russian legal regulation in this aspect is not so well developed. First of all, we should say that it is legally possible for joint stock companies, at least it is mentioned in the legislation. At the same time, in practice, there are certain difficulties concerning technical issues and some kind of confirmation of identity of the shareholders. But at least for joint stock companies, we have in the law specific regulations. However, for limited liability companies, there is nothing in the law about it, and the practice considers such online meetings as meetings performed by way of absentee voting. So with the use of the ballots and all the formalities. For joint stock companies, in comparison, online meetings are considered as joint meetings, but still it is required to use the ballots, and in this case it is quite similar to the absentee voting. Important is that for such kind of online meetings there is no need to comply with the requirements for notary certification or certification by the holder of the shareholders register if it is required by the law or by the bylaws of the company. So it is quite a good advantage and could be, let's say, used in practice and could solve the difficulties with associated with this notary certification or certification by the registrar. Moreover, we would like to say that this year, in the beginning of this year, certain difficulties arise with resolutions of sole participant or sole shareholder. It was clear and clearly stated in the law that such kind of resolutions can be signed just in a written form without any certification by the notary, by the registrar. However, the Presidium of the Russian Supreme Court in the judicial review on 25th of December 2019 established the requirement for notary certification even for the resolutions taken by sole participant, which means that the resolutions of sole participant shall be certified by the notary. And this approach of the Supreme Court was quite unexpected, and still we should say that even since this position was clearly stated by the Supreme Court, the court practice in this aspect is quite different. Some entities follow this recommendation, some entities do not follow, and the notaries also in some cases accept resolutions signed in a simple written form. Sometimes they could refuse to accept these resolutions. So considering this contradictory practice, we should say that it is advisable to provide in the charter of the company the provision that the resolution of a sole participant can be certified by means of a simple signature of the participant. Even though it is somehow stated in the law, the certain provisions should be also included in the charter to avoid any kind of disputes, any kind of difficulties about implementation of the position of the Supreme Court. What is also important is that situation with COVID presented a lot of difficulties for foreign general directors of Russian legal entities because of the fact that there were difficulties, and there are still difficulties for entering Russia. And for those foreign directors who at the period of when the pandemic started, they were present in not in Russia but abroad. The further return to Russia presented a lot of difficulties. Therefore, sometimes the daily management activity of the companies was under serious threat, and somehow it was required to solve this. In practice, it was solved and is still solved by means of issuing a power of attorney from the general director for Russian employees acting in this period on behalf of the general director. However, not all the powers can be easily delegated by the powers of attorney, and in this year, in 2020, it became quite important to use the mechanism with several directors. Just like to remind that this mechanism was introduced in the law from the 1st of September 2014, and it is used by some companies, but not probably not all the entities. However, now with companies that have foreign general director, probably this concept with several directors is becoming more and more important. Important is that first of all, the bylaws of the company should provide the concept of several directors. If it is not introduced in the bylaws, it should be done. And first of all, the provisions of the bylaws shall be updated in this regard. And after that, the registration of second or third general director can be done. Registration with tax authority and with the bank. So for some kind of period when there is a problem with return of foreign general director, solution with a second general director probably could be used. Also, we should say that the use of the management company, a special legal entity that provides management services to Russian legal entities, may be also an option just for the interim period. And this, let's say, concept should be also taken into consideration when we are trying to solve the situation with the general director. So from corporate law topics, we can move to migration law issues. I would say that these issues became even more hot than, more important than the corporate. due to the fact that the borders were closed, and currently there are certain countries with whom with which the borders were opened. At the same time, the number of countries is still not essential. The problems with migration law are still very important. When we are considering the most important migration issues, we should focus on several issues. First of all, this is execution of work permit and visa in current period with pandemic. Then this is a situation with migration registration, and situation with return to Russia of foreign employees and company family members. All these issues, let's say, presented a lot of practical questions, and some solutions were found. Some solutions are still being discussed, and all these issues also lead to the fact that migration legislation is being under discussion now for probable adjustment, because of the fact that some of the laws were adopted quite a lot of time ago, and they should be in compliance with current tendencies in practice, and also somehow consider the current situation. So we'll also speak a little bit about the adjustment of migration legislation. So when we are considering the problem with execution of work permit and visa, we should first of all say that the term of validity of some of the migration documents like visa, migration registration, and residence permit, the term of validity of these documents was extended a lot of time, and currently it is extended until 15th of March 2021, which means that even if the documents are already expired, they are still valid, and it is important for the foreigners who are currently located in Russia with the expired documents, and this means that these documents are still valid until 15th of March. Most probably this period will be further prolonged, because it was prolonged last year several times, and since the situation with pandemic is being continued, we could expect that further extension of the term will be done. However, this extension is not applied to the listed countries. I mean the countries with the restored flight connection. As I already mentioned, the number of such countries is quite small, and still probably it's not so important, because for most of the countries the flight connection is still not restored, and the borders are closed. So if considering the fact that we receive information that at some point with some countries the flight connection will be restored, and there are also some discussions about further extension of this listed countries. If such flight connection will be restored, the term of validity for the documents for the citizens of such countries will be prolonged for 90 days, from the date of such restoring. Another important issue is that for the work permit and the visa execution, sometimes it is necessary to ensure the physical presence of foreign citizens. For instance, for standard work permit, by standard work permit I mean the work permit for 1 year, which is not the same as a so-called highly qualified work permit. This year, it was stated that foreign citizens applying for such work permit and visa should stay in Russia. And also, here we should mention the fact that situation with standard work permit is still quite difficult, because the required conclusion of the employment service for attraction of foreign workforce in the current period is quite problematic to be received, because the priority is done to Russian citizens, not to foreign citizens, and quite often the employment service refuses to issue a positive conclusion. And in this case, the work permit cannot be obtained. Considering the physical presence of foreign citizens, it's important to mention that such kind of presence will be required for a period of about 2-3 months from the moment when if the positive conclusion is received. So how to ensure this in practice? This is a really very difficult question, because currently there are certain categories of foreign employees who are entitled to return back to Russia. And in this list, we can find, for instance, highly qualified foreign specialists, foreign citizens with a permanent residence permit, but we cannot see in the list the foreign citizens with a standard work permit, which means that, in fact, it's not possible for them to enter Russia. So the situation is like, it's not possible to enter Russia, and without this, it's not possible to receive a standard work permit. How to solve this situation in practice? Basically, there is no direct answer, but one of the solutions could be to find some purpose for foreigners to enter Russia. And one of such purpose could be education, could be a medical reason. And but with this reason, we should present this by certain medical documents. So I cannot say that this is a real solution of the situation, but at least this is one of the options to properly to enter Russia for foreigners with standard work permit, if they need to prolong it for another period. But of course, provided to the fact that presence of foreigners should be for 2 or 3, even 3 months, it creates a lot of problems if we consider this. For highly qualified foreign citizens, we should say that the situation is a bit better, because it is at least possible for them to enter Russia. However, they should be entered in a specific list of the Federal Security Service, which should be approved also by Ministry of Internal Affairs. This is provided for the cases when we need to obtain a new highly qualified work permit. In case we need to prolong the work permit, the physical presence in Russia will be required for the period of execution of the work permit. If we are speaking about migration registration, we should say that this year there were, the year of 2020, there were certain changes in this procedure, which helped a little bit to improve it, and it became a bit easier due to the situation to perform this registration. First of all, it is now possible to do the migration registration through the website and through application Gosuslugi, which could minimize the necessity of visiting state authority. Also, migration registration is now possible through so-called multifunctional centers, or MFC in Russian language, which is also better than to go directly to the migration authority to present all the documentation. And another important issue is that foreign citizens, as the owners of the premises in Russia, may act as inviting party, and in this capacity they can perform the migration registration. Previously, it was not possible. At the same time, even though there are a number of provisions in legislation that, let's say, helping foreigners in solving their issues with registration, with the work permit execution, we still should confirm that a lot of problems arise when we are considering situations with the return of foreigners to Russia. First of all, as already mentioned, for some categories of foreign citizens, there is a possibility to enter to Russia, but it is required to perform a certain approval by the relevant ministry. The ministry should be competent for the organization, for the legal entity where the foreigners is working. For instance, if we are considering the banks, the competent ministry will be Ministry of Finance. If we are considering companies, consulting companies, the competent ministry will be Ministry of Justice. And if we are speaking about companies dealing with the trade of some goods, the competent ministry will be Minpромторg, Ministry of Industry and Trade. These responsible ministries should approve the list of foreign citizens. Then this list should be submitted to the Federal Security Service, and the Ministry of Internal Affairs finally approves it and enters foreigners in a specific list. First of all, it is important to mention that before approval, we need to mention the planned date of arrival of foreign citizen. Also, we need to mention the place for crossing the border, I mean the name of the airport. And sometimes it is difficult to identify all this data before receiving of approval, because approval may take about two weeks. However, in practice, situation is that after receiving of approval, the date of entry or the place for crossing the border can be changed, so it will not lead to any problem with return to Russia, and it would be also a solution in this case. Also important to mention that approval by the ministry and inclusion in the list is also applicable for foreign citizens entering in Russia with the purpose of maintenance and installment of foreign equipment. From the one side, it is good that this kind of specialists are included in a list of foreigners who are entitled to come to Russia, at least to enter Russia, and provide the specific services in Russia. At the same time, we should say that it creates a lot of problems also with the approval by the ministries and all the instances. Here it is also required to mention that according to the Russian regulations, for those categories of foreigners, only single entry is possible, which means that when foreigners enter Russia, they can then further leave Russia, and the subsequent entry to Russia is legally not possible. At least this is provided in the Russian legislation. However, in practice, there are certain cases when foreign citizens enters Russia second and third time, and there were no problems. However, every time this is a kind of unexpected issue, whether the enter will be allowed or not. So this should be taken into consideration. Also important is that finally the company family members were included in the list of foreigners who are allowed to come to Russia, because previously they were not included in this list, and it created a lot of problems. But in the end of 2020, these categories of foreigners were introduced in the so-called exempt list. And finally, if we are speaking about foreigners with permanent residence permit, probably this category of foreigners has a lot of has more advantages than others, because at least in practice, this category of foreigners can enter Russia for with a multiple. It is possible for this category to enter Russia several times, so multiple entry is possible. At the same time, no approval by the ministries is required for these categories. So basically, the foreigners with permanent residence permit are now have a lot of advantages in terms of entering Russia. At the same time, when we consider the return to Russia by foreign citizens, we should say that certain requirements should be fulfilled. First of all, COVID-19 medical test shall be passed 3 days minimum prior arrival in Russia. And also the specific questionnaire for arriving persons should be filled in. Moreover, if we are considering employment activity, so for those foreigners who come to Russia with the labor visa, the employment activity is only possible after 14 days of isolation, and a subsequent medical test, COVID-19 medical test, shall be passed on 10th or 12th day after arrival in Russia. If we are speaking about adjustment of migration legislation, we should say that the draft of the law of the migration, let's say one general law, is being discussed, and probably very soon or later there will be one basic law about migration, which will combine provisions of certain legal acts that currently exist, and will regulate in details all the aspects concerning foreigners, concerning work permit, visa, concerning migration registration, and all the aspects that are applicable for foreigners. Just if we're discussing the draft of this law, we should say that 3 categories of foreign nationals will be introduced. It is at least planned to be introduced. Foreigners with short-term stay up to 90 days, foreigners with long-term stay, and foreigners with permanent stay. Temporary residence permits, which is in Russia as abbreviation of RVP, will be excluded and will no longer be issued. Also, specific ID cards will be introduced for those foreigners with long-term and permanent stay. These ID cards will include photo, biometry, and also qualified electronic signature, and will be valid for 10 years. Another important adjustment that is being discussed is the notification procedure for work permits, which means that it will not be required to receive work permit before employment activity, but the foreigner may start employment activity and then just perform a notification procedure about his or her employment, and this will be some kind of new procedure for work permits, which apparently will be much easier than the current procedure, and could save a lot of time and probably also expenses for this procedure. And also, we would like to say that from 1st of January 2021, a new kind of visa was introduced. This kind of visa is electronic visa. At the same time, it was there was an information that currently this issuance of this electronic visa is postponed until uncertain period of time. However, I think that sooner or later this postponement will be cancelled. We'll see how soon it will be and follow the adjustments in this regard. But we should say that this kind of visa could be quite useful tool for foreign citizens, because it can be executed quite fast, because just 4 days will be required for execution. No invitation will be required for such kind of visa, and important is just to mention that this visa is only possible for business purposes and just for single entry. So no multiple entry is allowed. It is currently valid with about 52 countries, and the countries of European Union are included in the list. And it is only possible if the entry of foreign citizens is done through certain cities. However, Moscow and St. Petersburg are, of course, included in this list. The maximum term of validity of this visa is 60 days, but the presence in Russia is allowed only for 16 days, not more. And this is important to follow the maximum term of presence in Russia. Just to highlight that voluntary medical insurance should be executed for the electronic visa for the period of presence in Russia, and the passport of foreign citizens shall be valid and not less than 6 months prior expiry. So should be also checked and taken into consideration when electronic visa is issued. And just I will say some words about the changes concerning the types of the visa that from 1st of January 2021 is in force, and there are certain changes. However, I will just highlight certain of them. First of all, the so-called visa for foreigners who come in Russia for maintenance of foreign equipment will no longer be considered as business visa, but will become a labor visa. From the one hand, is a good solution. From one hand, not from the one hand. From the other hand, not a good one. So first of all, the labor visa provides the possibility for such kind of foreign specialists to be present in Russia without any limitations within the period of validity of the visa, because for the business visa we have the limitation of validity, so it's valid only 90 days from 6 months, and with labor visa there is no such problem. But The disadvantage with the labor visa is that if the foreigners come to Russia with the purpose of employment, it means that they should follow the 14 days isolation. For business visa, it's not applicable. So this should be taken into consideration. Moreover, it is important that even though this type of visa is introduced in the legislation from the 1st of January 2021, still there are some difficulties with issuing of this new type of visa because of the need to change the regulation in this regard, and most probably there could be some difficulties and some delays in execution of the visa in January, February this year. And second important issue for type of the visa is that the type of the visa with the purpose of foreign employee, or in Russia, inosodrudnik, which was issued previously for the employees of representative offices or branch offices of foreign companies, also will no longer be valid, and the employees of Russian rep offices, branch offices of foreign companies shall execute the labor visa. Also there are some advantages and some disadvantages in this regard. First of all, it means that the situation when such employees received a visa with the purpose of foreign employee through the Chamber of Commerce and Industry and work in Russia on the basis of this visa, and in case there was no work permit for such categories, is no longer possible, because in practice we had such cases when foreign employees of rep offices and branch offices executed this visa through the Chamber of Commerce and Industry and did not execute a work permit through the Migration Authority. And from the one hand, they were legally present in Russia with the visa of foreign employee, but at the same time, they did not have a respective work permit. Even though formally it was a kind of a violation of legislation, in practice, it was not considered as a violation by the Migration Authority. But now, from this year, it's no longer possible. So the employees of representative office, branch office of foreign companies shall execute labor visa like the foreign employees of Russian legal entities, and should obtain also a corresponding labor visa. So basically, I tried to summarize the most important topics related to corporate and migration issues, and if there are any questions, I'm ready to answer.
Thank you, Igor, for your comprehensive presentation on corporate and immigration law. It is always difficult to find your path in such a complicated area like immigration law, and this is becoming even more true in these days with the COVID. We have two questions from the audience. The first one is from Maria Barone. She asks, can a person with a temporary living permit come back to Russia, and what is the procedure?
Yes, basically by temporary living permission, I understand this РВП, or разрешение на временное проживание in Russian language. These categories of employees with such kind of document are not included in the exempted list. I mean the list of foreigners who may enter Russia, because in this list we only have those with permanent residence permit, which is вид на жительство. So basically, it is not allowed for those foreigners to come back to Russia. And the second question is...
yeah, second, so there is no procedure. The second question is multiple entry for people with a permanent residence permit. Is the FSB document one still valid?
Yes, so for foreigners with permanent residence permit, no approval from FSB is required, so the document is not needed. At the same time, in the Russian regulations, it is provided that such categories, foreigners with permanent residence permit, may enter Russia only with single entry. But in practice, multiple entries are allowed. So basically, with foreigners with permanent residence permit, multiple entry should not be a problem.
Thank you, Igor. I have a question myself. Can permanent residence permit be an option for an highly qualified specialist?
Yes, this can be an option. I just would like to say that according to Russian legislation, we have two types of residence permit, permanent residence permit, I would say. One is the permanent residence permit applicable for all categories of foreigners, which is executed for unlimited period of time. And exactly this document now provides a number of advantages in terms of entering Russia for foreigners. Another type of document which is possible only for highly qualified specialists is this highly qualified specialist permanent residence permit. Just to differentiate, this type of residence permit is issued only for a certain period of time for the period of validity of the respective work permit. And unfortunately, this highly qualified permanent residence permit does not allow foreigners to use advantages presented to the first residence permit which I mentioned. So it means that foreigners with highly qualified permanent residence permit cannot use the advantages for multiple entry to Russia. Also, they cannot use advantage for non-compliance with the approval by ministries, by Federal Service of Security. So it is this document still creates probably some advantages for highly qualified foreign employees, but not the advantages which are significantly important in current period. I mean the advantages with the entering Russia and with the fulfillment of the procedure considering coordination with the ministries.
Thank you, Igor.